A prenup is really a way of protecting one's assets on a divorce, putting in place an agreement before you get married, which is trying to determine what will happen to your assets in the event that you get divorced, and hopefully avoid a dispute at that point because you've pre-decided what's going to happen. Just about anyone could have a prenup, but people who are really going to be looking at prenups are probably people who've got assets that they want to protect. And those are probably assets either that they have inherited or assets that they've come into marriage with. And typically, you might find that people who have had a business, for example, which they've built up before they get married, might want to protect that. But all sorts of people could consider prenups simply to try to get some sort of certainty at the end of a marriage if it doesn't work out, which otherwise, if they didn't have one, would mean that they'd probably have to litigate, which might be very expensive and also emotionally expensive as well. The first question that most people ask me about prenups is, are they worth the paper they're written on? And it's certainly the case that in the English jurisdiction, unlike in quite a lot of continental jurisdiction, there's no statutory recognition of prenups. However, since a case went to the Supreme Court some years ago, the courts have recognised prenups, provided they are basically fair, as having significant weight when the court comes to exercise their discretion on a divorce. And so therefore we do tend to advise clients that prenups are a good way of protecting assets in the event that someone sadly ends up divorcing after a significantly long marriage. People often ask me, how do I set about negotiating a prenuptial agreement? And the first thing I'd say is that you need to talk to each other. You both need to discuss whether this is something that you are both going to enter into voluntarily and cheerfully without taking too much of a toll on your relationship. And you then need to discuss and have a grown-up discussion about what a prenuptial agreement is going to do. So a prenup can be a fairly simple document which is simply protecting an asset, say a business, or it can be much more wide-ranging and prescribing all sorts of things that might happen on a divorce. Once you've decided that, you then need to come back to your lawyers and discuss with us how that can be put into a document, which can then be sent to your intended spouse's lawyers for discussion. We try and finalise a document that it respects everyone's feelings but tries to reach a harmonious agreement. Sometimes that's possible, not always, and sometimes there are some rather more tough discussions to be had. But ideally, what you're attempting to do is try to agree that document and get it signed about a month before you get married. One of the questions we're quite often asked about prenuptial agreements is whether or not it's necessary to give financial disclosure, and the answer is invariably it is in this jurisdiction. In the English jurisdiction, the courts expect parties to negotiate openly and know exactly what it is in terms of rights that they are giving up. So it's important that there's financial disclosure as part of that process. It's also important that both sides are independently advised, and a classic way of avoiding a prenup is to say that you had neither financial disclosure or indeed independent legal advice. We have quite a lot of international clients, and quite often they do ask us about jurisdiction of prenups, and there may be more than one jurisdiction in which they could potentially get divorced. That will quite often be determined by where someone's living or where someone's domiciled. When you've got more than one jurisdiction, it's not uncommon to have prenups in more than one jurisdiction, or at the very least have prenups that take into account the fact that jurisdiction may change throughout the marriage. One of the cases in which prenups can be particularly helpful is where you have got modern families who have had previous relationships, have children from previous relationships, and have competing claims against their resources. And it's quite often the case that if someone's getting married for the second time, having had children from first marriage and having had potentially a bad experience the first time round when they came to a divorce, But a prenup can be a reassurance for them, and it can be something that actually helps stabilise that marriage and means that both parties to marriage feel that they know exactly where they are and what would be the effect if, sadly, that relationship did not work out. So I think they're particularly useful for modern families. Prenups are not clearly confined to, say, traditional families where they are, say, a heterosexual couple. I have a lot of clients who are same-sex couples who have prenuptial agreements, and indeed actually also enter into postnuptial agreements as well. Postnuptial agreements is something that's rather quite often overlooked, but have similar validity in terms of weight given to them by the courts as prenuptial agreements. And they're increasingly used in cases where clients are trying to protect intergenerational wealth transfers, particularly. By that I mean where you've got, say, a father or grandfather who's trying to hand down assets to the next generation, but they don't want to see those assets disappearing out of the door if their son or grandson or granddaughter gets divorced a few years down the line. And so they can make it a condition that if they're going to hand over the assets while they're still alive, that the parties enter into a postnuptial agreement, which will then safeguard those assets in the event that the worst happens and that couple gets divorced. And that can be an alternative to just putting monies into a trust, which can have quite significant tax implications, and also clearly restrains the use that can be made of those assets by the beneficiaries. So postnuptial agreement, in terms of intergenerational wealth planning, is quite often a useful tool. Collyer Bristow have quite an expertise in prenuptial agreements, and we have been producing prenuptial and postnuptial agreements for clients for probably the last 2 decades. Certainly, we have, I suspect, on average, perhaps maybe a dozen prenuptial and postnuptial agreements in any one year, perhaps a few more. Some of those will be international, and some of those will involve very significant assets. Other of them will be involving more modest assets. We like to think that we offer very good value when we're producing these agreements. And apart from our expertise, we have a very deep relationship with our clients and are able to advise them on all aspects of their relationship, including quite often we, for example, would be advising about wills at the same time as pre- and post-nuptial agreements with our experts in the trust and estate planning team. We'd be able to help them with elements of tax in respect of their agreements. We also have very good international relations with a variety of lawyers in a number of different jurisdictions throughout the world, which can inform our advice on international elements. So we pride ourselves on developing deep and caring relationships with our clients and holding their hands through a process which can often be rather fraught and which needs to be handled particularly sensitively, and bringing that to a good conclusion, we hope, and a good start for their relationship going forward.